Welcome to the Virginia Civics and Economics Lecture Series. At the end of each slide, there will be a 5-second delay. Use this time to complete your notes. When you are done, push play and move on to the next slide. This presentation will begin in 5 seconds. Welcome to Virginia Civics and Economics Lecture 1.9 on Fundamental Rights, and let's look at these two historic pictures from Congress. The picture on the left is from 1789, which is early in our history, and the picture on the right is from 1866, during Reconstruction after the Civil War. Well, what are we looking at? The picture on the left is us adopting the Constitution and Bill of Rights, and the picture on the right is Congress proposing the 14th Amendment. So these two events secure most of our fundamental rights. The question is, what rights were secured by these people? We'll answer that question today, and with that said, go to the next slide. You learned that the United States Constitution and its amendments represents a balancing act between having a strong national government and protecting the fundamental rights of the people. Today we're going to look at how we protect our fundamental rights by examining two amendments. We start in the Bill of Rights with the First Amendment, which sets forth the 5 most important rights denied to the colonists by the British and prohibits Congress from making laws addressing these rights. It's not called the First Amendment for nothing. These were the 5 biggest problems our founding fathers had with the British. Because of this, the issue faced by the federal government is whether a proposed law or government action violates the First Amendment. In other words, is it constitutional? Is the government going to, or have they already violated your right to do something? Well, what are these 5 rights? The first one is religion. The government may not establish an official religion, endorse an official religion, or unduly interfere with the free exercise of religion. Sounds straightforward, right? Well, not exactly. The question is whether or not this right applies to all situations. For example, there is a debate over whether certain expressions of religious beliefs on public property, things like the 10 Commandments, menorahs, prayers before government activities, etc., should be allowed or banned under the First Amendment. So here's a state capitol, here's a display of the 10 Commandments. Is this legal or illegal? Then we have speech. Individuals are free to express their opinions and beliefs. However, again, there's a question about what constitutes free speech. Hate speech is not protected speech under the First Amendment, but we have yet to define what actually constitutes hate speech. In other words, where is the line between free speech and hate speech? We're not yet sure. Go to the next slide. We continue looking at the First Amendment by looking at freedom of the press or the media. The press has the right to gather and publish information, including that which criticizes the government. It's all free speech. That's not the case in all countries. In the United States, the press is guaranteed the right to criticize the government. But the press is limited in other ways. The press may not slander or libel. They may not make false statements about individuals, but even then we give the press some leeway. The press receives some protection if those persons are public figures. In that case, the person who had the false statements made against them must prove that the statement is false and that the statement was made to hurt the targeted person. Then we got to talk about assemblies. Not that type of assembly. Assembly. Individuals may peacefully gather in public, but the word to look at here is peacefully. Assemblies must remain nonviolent and otherwise not pose a public safety issue to other citizens. Finally, we have the right to petition. Individuals have the right to make their views known to public officials, and this right traces its roots way back into British history. The idea was first set forth in the Magna Carta, and today this occurs through lobbying and political action committees, which you'll learn about, and official channels including public internet petitions. But remember this, public officials don't have to listen. Go to the next slide. The First Amendment's been around since the beginning of the government, but then we have that Civil War and things are going to change. We're going to enact the 14th Amendment, which is going to do several things, including something called Selective Incorporation. The Constitution and Bill of Rights only applied to the federal government from 1789 to 1866, the year after the war ended. So a citizen was guaranteed rights like due process under the law and equal protection when dealing with the federal government, not the states. What if I told you you can't have it all? You might live in Virginia, but only the federal government can't violate your rights. The states certainly could. Well, we're going to fight this civil war and the North will be victorious. Even so, after the war, the South was still not providing due process and equal protection to all citizens. So Congress passed the 14th Amendment in 1866 to require the states to also extend due process and equal protection rights of citizens to the states. So now the states must provide their citizens the same rights as the federal government. Then something really interesting happened. The United States Supreme Court got involved, and you're going to learn all about the power of the court soon. What you need to know here is that the United States Supreme Court ruled in several cases that the 14th Amendment extends almost all of the rights found in the first 8 amendments of the Federal Bill of Rights to the states. We call this selective incorporation. In other words, the Supreme Court said that almost all of the rights found in the Bill of Rights need to be applied to state governments as well as federal governments, but not all rights are selected. Go to the next slide. Through selective incorporation, the 14th Amendment protects our rights from violations of both the state and federal government. But the 14th Amendment went farther as well. Let's talk about due process and equal protection. The 14th Amendment requires the states to follow the same due process protections as the federal government. What is a due process protection? Well, it all depends on which protection we're talking about. Substantive due process requires that state laws do not infringe or get in the way of basic constitutional rights given to us through selective incorporation. In other words, state tries to enact laws that rescind or restrict constitutional rights, stopped by the selective incorporation doctrine. The states cannot take away your federal rights. Procedural due process requires that individuals have the right to a fair and impartial hearing before the government takes adverse or negative action against them. What does that look like? Here's a Virginia license. The good news is this: the state can't just take away your driver's license. It's not like you can be pulled over and the police officer just takes your license. Nope. Instead, you get to go in front of a judge and the government decides whether or not it's right to take that license from you. Finally, let's talk about the Equal Protection Clause. No, that's a terrible pun. The 14th Amendment, though, also requires the states to extend equal protection guarantees to its citizens. What does that mean? Equal protection requires that the laws do not deprive a person of protection that is otherwise provided to others under the law. So the government cannot discriminate against you based on race, national origin, or sex. Here's the thing: we're still working out the details when it comes to sexual orientation, but we're getting there. That's it for this lecture, and I look forward to seeing you in class.